I'm Hava Leipzig-Holzhauer. I'm the Executive Director of the Konar Center for Tolerance and Jewish Studies. And a couple of housekeeping things. We're going to do the question and answer piece of the hour through the chat function. So if you have questions for the presenter, if you could send those to me, Hava, through the chat. If you have questions about volume or other Zoom issues, things that aren't working, you can't see the presentation, if you could send that as a chat message to Patricia Lapel, that would be fantastic. Otherwise, just try to remember to keep yourself muted. And if we remain a not so large group, we might switch that Q&A over to just self-unmuting and asking questions. And we're hoping to have a good 15 minutes at the end of the presentation for discussion before the hour's up. So a quick why are we here? We're here because we're a campus community and we seek knowledge and ideas and action to move forward towards positive community change and global change, and supporting each other in actualizing that Black Lives Matter is extremely important. So there's many tools that we use to accomplish this. And today's tool on this Zoom is education. We'll educate ourselves on the local specifics vis-a-vis free speech and assembly and peaceful protest and knowing one's rights. And we'll take this useful knowledge to better support ourselves and to support one another in our endeavors. And so with that in mind, I want to thank the other partners on this program, which are Community and Belonging, Health and Counseling, Social Work, the Center for Civic Engagement, and the specific individuals who were part of the programming, Lisa Durant-Jones, Jed Metzger, Jeremiah Knowles, and Leanne Charlesworth, excuse me. So thank you so much, everyone, for your participation and support. And most of all, thank you to First Assistant District Attorney, Jill Paperno.
Public defender.
Excuse me. My own history coming out naturally. I should read my paper instead of talking about stuff. Woo, public defender. And Jill Paperno is the president of the Monroe County Bar Association. She's the past president of the Greater Rochester Association for Women Attorneys. She's the first assistant public defender for the Monroe County Public Defender's Office. And in her 33 years with that office, wow, she has handled criminal cases and tried numerous felonies. She's author of Representing the Accused, A Practical Guide to Criminal Defense, and she's a frequent presenter at continuing legal education programs. So we're very lucky to have Jill with us here today. Thank you so much. Take it away, Jill.
Thank you, Professor Leipzig-Holzhauer. So the reason that I made that correction is because the Public Defender's Office is the office that defends people who are accused of offenses, whether they be low-level or high-level offenses, and cannot afford counsel. The District Attorney's Office is the office that prosecutes people. So first we're going to discuss constitutional rights because that's where we get the strong sense, the entitlement to be able to speak out against our government. And we do have such rights. The United States Constitution has many of those rights in the Bill of Rights. The Bill of Rights is the first 10 amendments to the United States Constitution, and we deal with them every day. It's an old document, but it's something that we are constantly quoting in our work in defending people accused of crimes. So the First Amendment is the one that you think of about your right to free speech. Congress, which meant the United States Congress, would make no law respecting an establishment of religion, various other things, or abridging the freedom of speech or the right of the people to peaceably assemble. So that's right in the First Amendment to the United States Constitution. It gets cited in cases all the time, so it is, as they say, a living, breathing document. The Fourth Amendment to the United States Constitution prohibits unreasonable searches and seizures. And why am I raising that? Because as people are getting arrested these days, they are having they're being searched, their property's being seized, and sometimes they're being released without any charges. So there's a real question of whether those searches and those seizures are unlawful. Then there's the Fifth Amendment to the United States Constitution, where you're entitled to due process of law. So I've highlighted that language. I'm going to just move through some of the constitutional things a little more quickly. and the 14th Amendment, which applies the United States Constitution to the states. So again, you have, you're not to be deprived of life, liberty, or property without due process. And in New York, we also have a constitution. So under the New York Constitution, we have similar protections in some ways to the United States Constitution. And New York courts interpret the New York Constitution and sometimes grant us broader rights than you get under the United States Constitution. So under Article 1, Section 9, there shall not be any laws abridging the rights of the people to peaceably assemble and petition the government. So there you have that right to assembly under the New York Constitution. You shall not have be searched or have your property seized without probable cause. Probable cause is often defined as the same as reasonable cause, but there has to be a basis for searching and seizing under the New York Constitution as well. And then here's an example in a United States Supreme Court case of analysis about what that right to assemble, what the right to protest means. And it's a case called McCullen v. Coakley. I don't want to go through the whole thing, but it's the idea that sidewalks, for example, in the language of the court decision, occupy a special position in terms of First Amendment protection because of their historic role as sites for discussion and debate. These places, which we've labeled traditional public fora, have immemorially been held in trust for the use of the public. And it goes on with that kind of language. This was a case in which there was a buffer zone and in front of a Planned Parenthood clinic or some other form of clinic, and protesters were objecting to the buffer zone or being removed from that area of the sidewalk. But you can see the language of the Supreme Court in saying these are special places and we still have that right to protest and to assemble in those places. So even though we have these rights granted under the United States Constitution and the New York State Constitution, there are limits, and sometimes we disagree with those limits, but there are limits that courts can set or that governments can set. So it might be the United States government setting some limits through legislation, or the state government through its own legislation, or even local governments. And we have an example of that coming up later on in this presentation. But this is language from that case I was reading a moment ago. Even in a public forum, the government may impose reasonable restrictions on the time, place, or manner of protected speech, provided the restrictions are justified without reference to the content of the regulated speech. So they can't say, well, everyone in favor of choice gets to speak and everyone opposed doesn't get to speak, or vice versa. It has to be time, place, and manner based on other concerns, such as safety. You've probably heard the expression, you can't yell fire in a crowded theater. And that is the idea that although you may have the right to free speech, there are restrictions. And if your speech is going to cause danger to others, that's one of the kinds of restrictions that is permitted. And I think actually Professor Leipzig-Holzhauer may have some examples if we get into the discussion later on about free speech issues. So just know that it is lawful for the government to impose some restrictions, and that's where we often butt up against, I want to speak out, I want to assemble, I want to exercise my First Amendment rights, and the government is saying, well, you can't be here after 11, even if you're exercising your First Amendment rights. And then the question is this lawful or not? So I'm going to now go through some of the laws that we've seen, some of the statutes we've seen that are limiting or being applied to people and that are being charged against people who are protesting. There are federal, state, and local statutes. So federal is when the federal government charges you, the government of the United States charges you with violating the law. State is when it's New York State. The people of the state of New York is how those cases are often described. The people of the state of New York versus Tom Smith, for example. And local, you might see that a local ordinance is alleged to have been violated, like the local curfew law. So one thing we've heard recently from the Attorney General of the United States, William Barr, is that they're thinking of charging sedition against protesters. And this is not normal. This is not something we generally see, that people protesting against some aspect of government are going to be charged with sedition. We know that Barr has taken a position that the Black Lives Matter movement is it's radicals and Antifa and things like that. And he's seriously looking at prosecutions here. So later on, I want to talk about social media and the concerns you need to have and bear in mind when you're dealing with social media and the things you say, because the federal government is looking at social media right now. So, okay, there's my attempt at, I don't know if it's humor or sad, but that's Bill Barr right there. So there's a charge called seditious conspiracy. And this is the language of the statute. It's a federal statute. If two or more persons in any state or territory or in any place subject to the jurisdiction of the United States conspire to overthrow, put down, or to destroy by force the government of the United States, or to levy war against them, or to oppose by force the authority thereof, or by force to present, hinder, or delay the execution of any law of the United States, or by force to seize, take, or possess any property of the United States, contrary to the authority thereof, they shall each be fined and imprisoned for no more than 20 years. So what does that mean? This is one of the charges that Bill Barr is talking about filing against people. And if you forget the overthrow of the government and kind of move on to the later part, possess any property of the United States, if they are looking at protests at federal buildings as an attempt to possess property, or delaying the execution of laws of the United States, if they're looking at any of those kinds of things, they may try and charge people with this. I don't think there have been seditious conspiracy charges filed recently, but he has talked about filing those sedition charges. Before we get to New York law, there was a federal riot charge filed recently in Rochester, and that's one of the things I want to talk about. It was a riot charge filed against one of the protesters involved in protesting the killing of Daniel Prude. So I don't have that statute up because that happened before I put together the PowerPoint, but it's something that we need to be really mindful of. So in New York, there are different levels of offenses. There are felonies, and felonies are the most serious offenses in New York. They can lead to, if there's a conviction, prison time or extensive probation time, a loss of certain rights. So the felonies that could be applicable to protests could be assault in the second degree, and I'll explain these all in a minute, riot in the first degree, arson, and criminal mischief in the third degree. In New York, lower level crimes are misdemeanors. And so they're still crimes. You still could have a criminal record as a result if you get convicted. And the misdemeanors can include riot in the second degree. We're seeing these charges: riot in the second degree, resisting arrest, obstruction of governmental administration, unlawful assembly, criminal trespass, and criminal mischief in the fourth degree. And then violations are the lowest levels of offenses. Disorderly conduct, trespass, and harassment are examples of what we might see in prosecutions of protesters. Okay, so the difference is, as I mentioned before, if you get convicted of a felony or misdemeanor, you're going to have a criminal record. It can affect potentially loans, although loans I think, are mostly affected by drug offenses, but I can't really speak to that. I know drug offenses do affect loans. I'm not sure about other offenses and how they affect. I bet felonies probably have an impact. They can affect job status, status as a student potentially. That's, each school has their own policies. On a violation, you won't have a criminal record if you get convicted of disorderly conduct or some local offense that's a violation level, but the information may be available to prospective employers. So let's talk about my son for a second. My son is kind of a bonehead sometimes, and when he was graduating high school and about to go to college, he did some boneheaded things, one of them involving an event at Darien Lake. He has a different last name from me, so don't start Googling Paperno and see if you're going to find him. You're not. But anyway, so we wound up getting a decent resolution for these misdemeanors that were reduced to violations, except they were on the internet because the local papers reported those things. And so we actually tried to have some of them removed, but there's no right to have that stuff removed from the internet. One place was kind enough to say, okay, he's doing well in college, blah, 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 boyish, stupid things. We're going to remove it. And that's probably partly his white privilege. But the other place said, no, we're not taking it down. We want to keep this up. And actually, he was applying for a semester abroad, and this was last year. And one of the reasons that he did not get the semester abroad at that time was because of that incident. That was, he had to tell the truth about it, but if he hadn't, it would have been up on the internet anyway, easily found. And then sadly, he did get this semester abroad for this semester, but that didn't work out this year. So just be aware that there are consequences if you are arrested. It may be reported on the internet, and you may not ever get rid of that. And so you have to think about how's a prospective employer going to be seeing this, and how will it impact my future? I'm not telling you not to protest. I'm just saying that when you make choices, you have to understand that sometimes there are going to be negative consequences to those choices. I've spent many, many years protesting, but I have certain limits for myself as to what I'm willing to do and not do because of my law license and the things that I want to do in my work. So felony charges. Arson in the third degree is one of the felony charges we've seen, and this had to do with the burning of police cars in some of the first protests. A person's guilty of arson in the third degree when he intentionally damages a building or motor vehicle by starting a fire or causing an explosion. It's a Class C felony. That means that it's punishable by up to 15 years in prison. That doesn't mean a person's going to get 15 years on their first outing, but if you have an arson in the third degree conviction, that is hugely problematic. I can safely say that that will impact your employment in the future if you do get convicted of that, even if you got probation. Criminal mischief in the third degree is a charge that with intent to damage property of another person having no right to do so or any reasonable ground to believe they have such right, you damage property of another person in an amount exceeding $250. So this is a felony level offense of damaging property, and the property just has to be worth more than $250. You scratch the side of a car, you've got criminal mischief third, right? Because we know how expensive it is to fix cars. Again, with my son, we know how expensive it is to fix cars often. Okay, so riot in the first degree, we're seeing some of these. And these are the state charges again. Person's guilty of riot in the first degree when he simultaneously with 10 or more other persons engages in tumultuous and violent conduct and thereby intentionally or recklessly causes a grave risk of causing public alarm. And in the course of and as a result of such conduct, a person other than one of the participants suffers physical injury or substantial property damage occurs. Now, with a lot of these charges, you're going to see this and say, well, wait a second, I'm not engaging in tumultuous and violent conduct. But when we're dealing with charges, charges are in the eye of the beholder, the charger, the police. So you may feel very strongly, and you may be absolutely right, that you didn't engage in tumultuous and violent conduct, but they can still charge you, and then you're going to wind up fighting it out in court. So again, these are things, some of these are beyond your control if you're in a demonstration and they start unfairly charging people. When people are charged with offenses that are higher than something they've done, that's called overcharging, and we've seen plenty of that. And not all of these have to be intentional. There's also the potential for recklessly causing a grave risk. And under New York law, reckless is defined as being aware of and consciously disregarding a serious risk that your conduct is going to cause a particular result. Assault in the second degree is a charge that we deal with all the time here in all sorts of contexts. And you're thinking, wait, I haven't seen anyone punch anyone or do anything to harm a police officer. The weird thing about assault in the second degree, there are a lot of subdivisions under New York law, and subdivision 3 specifically relates to police officers and peace officers. And what that is that in the course, if they are in the course of performing an a lawful duty, any of these, there's a whole list of who's covered by this assault in the second, but let's think police officers and campus security. If they're in the process of performing a lawful duty and the person charged is alleged to have caused physical injury to such police officer, that can be an assault in the second. And you're thinking, well, okay, but no one's punched anyone, no one's kicked anyone. The law is really broad on this. So if a police officer winds up tripping and falling and hurting themselves as they're trying to apprehend someone, that can result in a charge of assault in the second degree. If they are taking someone and trying to handcuff them and they twist their wrist, that can result in a charge of assault in the second degree. So this is a very broadly used charge and very often, from my perspective, unfairly charged, because it's not that you have to be the actual person directly causing it. It's your actions cause the police officer to feel compelled to engage in an arrest or something, and then the police officer falls and they get hurt, and you can face those charges. Misdemeanors. So there are several misdemeanors that we've seen getting charged. One is obstruction of governmental administration, and that's when a person intentionally obstructs, the administration of law or other governmental function, or prevents or attempts to prevent a public servant from performing an official function by means of intimidation, physical force, or interference, physical interference there, or by means of any independently unlawful act, or by, and then some other stuff relating to telephones and stuff. So for example, you know, if there are lasers pointed at law enforcement that prevent them from engaging in their duty, or maybe even, I don't know how the drone law works on this, but things that are affecting drones, maybe that could be charged as, we call it OGA, obstructing governmental administration. But just be aware that that statute is there. And then there's resisting arrest. A person's guilty of resisting arrest when they intentionally prevent or attempt to prevent an officer from engaging in an authorized arrest of themselves. So resisting, it has to be an authorized arrest, and that's where a lot of the fight is on these charges when we're defending people. Another misdemeanor charge is unlawful assembly. And this is one we saw actually recently. They were about to charge about 30 people with unlawful assembly from one of the protests. And I was having conversations with someone in the police department about how that's overcharged. There's no way that they're going to be able to prove this. And they wound up not charging them in. I'm not going to claim credit for that. They were probably hearing it from other sources too. But a person's guilty of unlawful assembly when they assemble with 4 or more other persons for the purpose of engaging or preparing to engage with them in tumultuous and violent conduct likely to cause public alarm, or when being present in an assembly which either has or develops such purpose, they remain there with the intent to advance that purpose. So unlawful assembly, you know, when the police starts telling crowds this is an unlawful assembly, that they're laying the groundwork to file those charges or other charges. And what's tumultuous conduct? I haven't really looked at what the cases define it as. I don't think it's defined in the penal law, but likely to cause public alarm. You know, there may be some conduct that could fit within this statute, but I think everything that I saw that day that they were charging those people with was not unlawful assembly. So again, that's something people have to be aware of. Criminal trespass in the 3rd degree. We've seen some of these charges, and I think they're actually mischarged as well. And that's a person's guilty of criminal trespass in the 3rd degree when they knowingly enter or remain unlawfully in a building or upon real property which is fenced or otherwise enclosed in a manner designed to exclude intruders. This charge came up when there was a press conference open to the press, so the building was not fenced or otherwise enclosed in a manner designed to exclude intruders at that moment. And yet some of the protesters said, wait a second, you know, we have a right to be here. This is the public safety building and you're inviting all these people in. So we want to go hear this press conference too. And they wound up being arrested and charged with criminal trespass 3rd. Criminal mischief in the 4th degree is intentionally damaging property of another person or participating in the destruction of an abandoned building. We really don't have to get into that much, except, you know, when there have been events where buildings get destroyed, you could be looking at criminal mischief 4th or other charges. Okay, this is the Rochester curfew order, and this was the order signed by Mayor Warren, limiting people gathering after 11 p.m. and before, I think it was 5 a.m. And she had the authority to issue an emergency order under the executive law of New York. But I think there are some real concerns and issues with this order, and I'm just going to move on. So while they barred certain conduct between 11 p.m. and maybe it's 8 a.m., I don't know, they allowed outdoor dining, and they also, they prohibited groups of a certain number of people to gather unless you're family members, but they allowed outdoor dining, they allowed conduct, I think, in bars, and the reason given within the order, I believe, is to limit COVID exposure, but at the press conferences, it was for safety of the community because of the violence she was claiming, the gun violence that had been going on in the city. So the order is that between the hours of, it is 5 a.m., 11 p.m. and 5 a.m., it shall be unlawful to gather in groups of 5 or more in a public place in the city of Rochester. For purposes of this clause, a public place includes any outdoor premises, including but not limited to streets, sidewalks, parks, parking lots, vacant lots, and it's a Class B misdemeanor. And then also between those hours, it's unlawful for groups of 10 or more unrelated individuals to gather inside any location unless there's an alcohol beverage control law license. So it seems like there are some issues there in terms of if this was designed to prevent COVID, then how is permitting people to gather in a bar helpful with that? And if it's designed to prevent COVID, all these other carve-outs they had, you know, dining outside, don't really make a whole lot of sense. And when a law is, it restricts your constitutional rights more than is necessary in order to achieve the goal, that's called overbreadth. Or I'm sorry, that can be overbreadth, that it reaches too far into lawful conduct. So if a law does that, it may be unconstitutional. And there are some other constitutionality issues with the curfew, I believe. And we'll be seeing how courts deal with it, because we're going to be filing motions challenging that in court. And I know that there's already a federal lawsuit filed on that. Okay, so some of the violations that we're seeing: disorderly conduct is when with intent to cause public inconvenience, annoyance, or alarm, or recklessly creating a risk thereof. So being, again, reckless is aware of and consciously disregarding the risk that you're creating, public inconvenience, annoyance, or alarm. A person does any one of these 7 things. And what we tend to see is charges for unreasonable noise. Abusive or obscene language actually is First Amendment protected generally. So I haven't looked at the cases on that in a while, but that may not even be a constitutional subdivision. But then also obstructing vehicular or pedestrian traffic. We have seen charges on that for the demonstrations that are in the street. Congregates with other persons in a public place and refuses to comply with a lawful order of the police to disperse. So remember I said a few minutes ago that sometimes the police are starting to issue these orders to disperse, and the goal for them is to lay the groundwork for this charge. And harassment in the second degree, that can be a variety of contact. We haven't really seen these too much, but just be aware that it's a violation that exists. It's threatening to subject someone to physical contact, so you have to be aware of that, with the intent to harass, annoy, or alarm. So, you know, sometimes when people are speaking in anger about some of the things that have happened, and they express these, you know, very vague intent to, you know, we're going to do this or that if this community doesn't comply, they're potentially laying the groundwork for later charges, and I'll talk about that shortly. And then there's trespass, knowing or remaining unlawfully in or upon premises. So those are the violation level offenses. So let's talk about arrest procedures and protecting your rights. Before you protest, before you go out and protest, I saw all these things on the internet about if you're going to protest, you should write your name on your arm, or phone number rather on your arm of someone you can call, and things like that. And I thought, well, that's really excessive. We don't need to do that. I can see I misspelled protesting here. We don't need to do that in Rochester. It's not crazy like that. Well, it is crazy like that. And I have watched a lot of videos. I've taken statements from a lot of people about what's happened, because there's going to be a lawsuit filed about the conduct of the police. But it hasn't been filed yet. And right now they're doing things that I have been pretty surprised at. And I have spent a lot of time observing Rochester police behavior. So before going out, let someone know where you're going. Bring identification. One of the reasons I'm telling you that is because the police generally have to release on the charges, the low-level charges that people are facing. But if they can't identify you, then they may not release you. They can hold you overnight and have you go in front of the judge the next day. And they shouldn't, because the law says they can identify based on the information you give them. But that's one of the ways that protesters have been detained for far too long. Write a phone number of someone to reach on your arm. This is where I thought it was silly and an overreaction, but now I completely support that. Police take phones, have been holding the phone, some are returned broken, so you're not going to be able to rely on your kind of external hard drive telephone for remembering phone numbers. Write it on your arm. Do not carry any weapons or drugs that may be taken from you on a search incident to arrest, or you can face charges for that. And if your phone has photos or content you don't want the police to see, even though the law requires they have a warrant to look at it, I am not telling you that they are doing what they're supposed to be doing, so don't bring the phone with you. If an officer tries to arrest you, if you run, you can face other charges. If 100 people run, they may not be able to catch them all, so it's a judgment you're going to have to make, and I'm not telling you to do one or the other. I'm not telling you to refuse to obey a lawful order, but recognize that if you run and they have a basis to charge you, you may be adding additional charges. Do not physically resist or use words that reflect an intent to resist, because then you're going to wind up with that resisting arrest charge. Don't get in the way of another person's arrest, but I would suggest you record it on video and save the recording to the cloud, not Facebook. Facebook's fine, but Facebook recordings have been deleted recently, and we believe that that is deliberate. So things that people are thinking they shared and they saved, they're not. Save it some other way. If the officer is using excessive force, scream out what the officer's doing so any observant can record it. There's actually a video from these protests of a woman saying, "I can't breathe." And I spoke to that woman and she could not breathe. And you'd think they'd know better after March, but this was in August. "My arm can't move any further." Say those things and hope that someone's recording. If you see an arrest, do not interfere, but record it while not getting in the officer's way. And this can subject you, this is a decision you're gonna have to make, because officers have then been turning their ire on the people recording. So I talked to a journalist who recorded, the police tried to get in the way, he continued to record, they took the person away, and then after that he starts walking away and they shot him in the back with a pepper ball, which they're not supposed to do. So what happens after the police detain you? They should only detain if there's reasonable suspicion that you have committed or about to commit a crime or probable cause to arrest you, or if they observe a violation level offense in their presence, those violation things I was talking about, like disorderly conduct. Sometimes they take people in and they try to figure out if there's a charge and what to charge. We suspect this is happening with protesters. They take them in and then eventually they let them go and they don't charge them with anything. They're not doing you a favor. They shouldn't have taken you in the first place there. And they should not hold you without the intent to charge you. So what will likely happen? If they plan on charging you for most protest-related offenses, they cannot hold you in jail with a few exceptions. They should issue you an appearance ticket on the street, but with protesters, they haven't done this. They've taken them into custody. They have taken them out to the Monroe Correctional Facility in Henrietta and then left them there to find their way home. And that can happen. They might leave you out there at 3 in the morning. That's why you need that phone number on your arm. And just to expect that things may get kind of screwy. They may take you to a police station, place you in holding, take your mask if you're wearing one, and they may not be wearing masks. So just realize that that's a potential risk as well. And what else might happen? Well, their badges are going to be covered. That's something they've done extensively lately. They may not answer your questions. They may detain you for an unreasonably long period. If you're in need of medical care, they may not provide it, but you should tell them. They will take your phone and other personal property, and when released, they may leave you at a location which is not where you started and possibly without your phone or a ride home. ID, I talked about this a little bit already. It's not required by law, but have it with you. And if you have it and you show it to them, that should be adequate. It may not, because they've insisted in some cases that someone else bring a different ID down to the station for someone to be released. There's nothing in the law that requires that, and that's probably going to wind up in that lawsuit. They may refuse to accept your ID. In one case, they refused to take a passport. That's probably going to wind up in a lawsuit too. I mean, it's one lawsuit to change all the conduct of the Rochester Police Department. If you're charged, you'll be given a date to return to court. You may be held if the charge is a qualifying offense under the law, and you may be held if the police feel your ID is inadequate. Once you're detained, ask, these are really, I want you to remember this, ask if you are free to leave. If they say you are, do. If you can, remember the times of when you were taken in and when you asked to leave. You won't have a pen with you. I hope you have a better memory than I do. Ask for a phone call. The law says you get a phone call after arrest. What happens if they don't give it to you? Really nothing, although it may wind up in that lawsuit. Try to remember the time of that request. Call a lawyer or call a friend and ask them to call the public defender's office. We have business hours though, and tell the public defender staff you asked for a lawyer. We can't just represent people if they're in custody and we haven't received a request. So it's got to be that the person arrested asked for a lawyer. Have your friend convey that. We cannot provide lawyers to those who are not financially eligible and those who do not ask for lawyers. Ask what the charges are that are being filed against you. Don't argue. You may be charged with charges that are higher than they should be, and that's called overcharging. Tell the police you do not consent to a search of your phone or person. They may want to look through your phone and say, hey, do you mind if I look through this? No, I don't want you looking through it. Do not answer any questions except those relating to your identification that can help get you released. Lately, the FBI has been in on some of the questioning. So now we're looking at federal charges like sedition, like that riot. If the FBI tries to question you or any investigator does, say you want a lawyer and you do not want to talk to them. They may threaten you. Stick to your requests. Keeping your mouth shut, I'm sorry, but I got to say it that way, at the time of your arrest might be uncomfortable. It may not be something that you're accustomed to, but it's going to save you a lot of aggravation and sadness later on if they try and use statements that they got from you at arrest in a prosecution for riot or sedition. Ask for medical care if you need it. Note the time of your request. If you're injured, try to ask for a supervisor and describe the injuries. If you want them to make note of the injury, be able to establish, you want them to make note of the injury and be able to establish their failure to provide care. If you get pepper balled, I've spoken to 2 people who got infections from the pepper balls. If you start feeling funny after those pepper balls, make sure you see a doctor. If you're held, you should be arraigned, brought before a judge, or assigned counsel. If you can't afford counsel, advise of the charges, have a plea of not guilty entered, and be released, or have bail set depending on the charge. And if you're released, check to see if your phone works. If not, tell the officer releasing you it does not and ask how to file a complaint. Note the officer's name. They may claim you never complained. It's not likely you'll get them to cover a repair, but again, we want to gather information. Reach out to me at the public defender's office if things went south in any of these areas, because for the lawsuit. If they keep your phone, and just to make clear, I'm not filing the lawsuit, I'm helping other attorneys who are working on that lawsuit. If they keep your phone, make sure you advise them that you had one and you want it back. Ask if there's a form you can fill out noting you did not get all your property back. They might have you sign a property return slip. Make sure you note what you did not get or what is broken. And once you're out, if you feel you qualify financially based on income or on your parents' income, if you're under the age of 21, you can contact the public defender's office. If you don't qualify financially, you should retain counsel. Make sure you wear a mask to court. If you were injured or excessive force was used, you may want to be included in that anticipated lawsuit, and make sure you see a doctor. And here's a quick lesson in criminal law, but Hava, I know, I'm sorry, Professor, I know you wanted me to stop at 12:40. Do you want me to go over this first?
Finish up. Go ahead. We have a few questions, but we still have time.
Okay.
And you can call me Hava. It's like Cher or Madonna, whatever you want.
Okay. Lady Gaga is so
exactly.
So anyway, this is something that I added on afterwards. Here's a quick lesson in criminal law. Most crimes involve mens rea, a state of mind, and actus reus, an act, and those have to be proven at trial beyond a reasonable doubt. For many crimes, the mens rea is intent, that you intended to cause the result that it was caused, and the intent to engage in certain conduct. For others, it's recklessness, that you are aware of and consciously disregarded that the serious risk that your conduct was going to cause a certain result. So why is this important? It looks like law enforcement are reviewing social media. So this what happened in that federal riot case recently, and gathering deleted Facebook information. That's what I'm concluding from that case. And in general, spying on people. So to collect evidence to establish the mens rea, that state of mind, they may be looking at your Facebook or whatever the contemporary stuff is now. And even if you erase it, they still have access to the old stuff. They can get warrants and get information. So if they see in a post, we ought to, burn this city down or something, and you're joking, you're expressing rage with friends, and one of your friends starts a fire later on, you may be charged as part of a conspiracy or maybe as an accomplice. So I just want to caution you to be really careful about what you say on social media, because you don't have to have the expression of intent like, hey, I'm going to set fire to this police car right now before you do it for them to conclude that there's intent. It might be that if there were several weeks ago where you said we ought to burn things down because they're just horrible in the way they're treating people or whatever, and you were just speaking with friends just enraged about what had happened with Daniel Prude, they might have that from weeks earlier. Now one of your friends might set fire to something, and they're going to put those two things together. Look, you've got the mens rea. It doesn't have to be at the exact moment that it was expressed. And the actus reus, we have a conspiracy or we have an accomplice liability. So you got to be really aware that social media is being viewed now. And it wouldn't surprise me, in that case that we just saw federally, one of the things that was noted was that there was mention made by the person posting of a Molotov cocktail that was later deleted. I would suspect certain phrases are automatically lighting up FBI screens across the country. And I would suspect that some of those websites may be put up by the FBI in order to try and entice those who may be interested in participating in the more violent conduct or are just curious. They may bring them to the website and then tag them and start watching them and collecting their information. So I may sound paranoid. It doesn't mean I'm wrong, and you should be a little paranoid too. So just be careful. Our Constitution protects the right to protest and free speech, but there are restrictions I talked about before. Did you want to add anything, Professor Leipzig-Holzhauer?
I'd like to give everyone the opportunity to take questions. I think that this was very comprehensive, and, I always speak about it with my students and others, that we have a toolbox for advocacy, right? And the law is one of those tools. But when it comes to protesting, it's really a balancing act between both, doing the good work that protesting allows in making a loud statement and getting people to hear us, but at the same time wanting to protect ourselves. And I think the information you shared in your presentation is a great body of information on that balance. So I'd like, if people want to unmute themselves and ask questions, I will ask one that came in from a student about, it's a little bit of a pivot, but it's about a felony charge for pointing a laser at a drone that just happened in Rochester. Do you know about that? Is it related? What can you share?
So good guess on my part. I don't know about it, but I talked a little while ago about pointing lasers at drones and whether that could be, for example, obstructing governmental administration. The drones have been flying over the protests, and my guess is they're collecting photographs, and they're going to try and use facial recognition software, which does not just exist on NCIS. It's real. It's also racially disparate in how it processes. It's more incorrect in people of color, trying to connect people of color. But anyway, so I think that could be an obstructing governmental administration, perhaps. If it disables the drone, I think it could be a criminal mischief. I don't know the specific charge, but that would not surprise me at all.
Great. Thank you. And again, here's another question. I'm wondering about, this is from Leanne, I'm wondering about our students whose rights were violated when they were arrested and who have been overcharged. What are their odds of succeeding in reducing their charges and perhaps bringing a case or a collaborative case?
Okay. So I mentioned a few times a lawsuit. There is a lawsuit that's being pursued by a New York City firm called Neufeld, Scheck, and Bruston. It's a very well-known civil rights law firm. It hasn't been filed yet, but what they're doing is they want to make changes in the Rochester Police Department. So they're filing a lawsuit challenging the civil rights violations. It doesn't mean that any one person's going to get a lot of money from it, but it's to change the practices here. There may be some lawsuits for people who were injured. So generally, if a person's rights are violated, say they don't read you Miranda warnings, and then they question you. If they don't read you Miranda warnings and they never question you, it kind of doesn't matter. But let's say they take you into custody, they hold you for a few hours when they should have just written you a ticket. Maybe those few hours are a violation of they are a violation of your rights if they should have let you go. But are you going to find a lawyer to take that individual lawsuit and sue for it? Maybe not. If you wanted to join this lawsuit when it's finally written, and we're all working on it, I've been gathering statements for weeks now, that's a possibility. And the goal there, for the most part, is to make change. There may be some individual lawsuits from people who had very serious injuries, like a broken nose. And I'm not trying to say it's not serious that they did these things to people. The only reason the police should be using force is for potentially as a last resort when they're trying to disperse the crowd. But when these crowd dispersals occurred, they were kettling people, pushing them into one space, and then using force against them. They were deliberately aiming at people. As people were fleeing, they were sniping at them from a garage ramp. So that's not the intent for use of force in these kinds of things. But anyway, so low-level injuries and low-level periods of detention for something you shouldn't be detained for is wrong, but you're probably not going to find your own lawyer. Now, if you're in criminal court and it's overcharged, I think there's a reasonable chance that you're going to get judges to reduce the charges. And if not, you go to trial, but it takes a while before you get to trial, especially with COVID. Everything is happening very slowly. So the trial that might have happened in 5 months might take a year now before you get to trial. I don't know if that fully answers the question.
It does, and there's more questions that have come in here, but one more thing I'll just add to that, which came up in my class last week. I had Don Thompson, who is one of the two main attorneys representing the Prude family. And what he shared, I think that's relevant to what you just said, is that even if they get arrested and it's unlawful, you still, for the rest of your application life, are answering the question, were you ever subject to arrest, right?
Mm-hmm.
And you're supposed to answer honestly, yet that question really isn't supposed to be asked, because being subject to arrest doesn't mean you were ever found to have done something unlawful. So it creates, you know, a long-lasting complication. But I think after this presentation, I'll make sure to collect the contact information for the public defender's office, the contact information for the big case that's being put together for the unlawful protest charges, and also for some private attorneys for those who don't qualify. And then we can have that available for our students here. So here
Don's
is
doing a lot of that work for people who are arrested. And his law firm is one of the law firms on that case that I'm talking about. I'm actually feeding him a lot of the statements that I've been collecting. He and I wound up being the people to try and generate the idea for it. And then he got the New York City firm.
Wonderful. I'm going to give you two questions at once that are both different. All right. So your memory, we got two questions. One is we have a staff member here who's still very upset about one of our students who was at City Hall eating breakfast as part of a protest and was arrested and ultimately charged with a violation, which included having to go through a cavity search and some, you know, which seems extremely severe. So, you know, can a case here be brought? Is this, what would we do in this case to make sure that this, you know, student's supported? And then the second and different question is, has the Rochester Police Department been known to overcharge in the past, or is this something that is sort of new, related to what's going on right now, you know, causing an unusual reaction or a turn in the way they're used to reacting?
Okay, so with respect to the first question, that's outrageous and ridiculous, and I can't help but wonder if that student was treated differently, perhaps based on race, but I'm jumping to conclusions there maybe, I don't know. In any event, if that person wants to reach out to me, we can take their story and have that considered as part of the lawsuit that will be brought. If they wanted to file an individual lawsuit, I'm not sure that they'd find someone, but they might. I mean, Don's firm is taking some of the individual lawsuits, and he can make that judgment. And yeah. I'm sorry, is there someone else? Okay, so that was the first, and the second, my memory is not that good. What was the second question? Just give me hum a few bars.
The RPD, is this unusual?
Oh, no, okay.
Okay.
So the excessive use of force is something that we have seen among certain officers and in certain communities my entire career. I mean, and the overcharging we have seen at times over the years, it's pretty consistent. And, you know, a DA can opt to reduce, or the grand jury can reduce. It doesn't always happen. So we're always fighting overcharging, but we've seen it now with large groups at a time. This Rochester Police Department, it's one of the reasons that this firm is interested, has a history going back to the 70s of excessive use of force and unprofessional conduct. And I'm not saying every single member of the police department does, but we don't hear them speaking out. There was just a law proposed in Buffalo that officers who see another officer do something improper and don't speak out can be subject to discipline. And I would love to see that here. So it's not unique to this era.
Thank you. I had one question, and then up here, one just came in. Given what we know is happening with the RPD and what you're confirming based on your interviews, you know, so I'm going to reframe this question. Students come to different staff members and members of the faculty, and they talk about using this tool, right? Going to protest and what they should do. And you know, some of what you shared makes us very concerned that if we encourage them, you know, they're really putting themselves in harm's way in a number of ways. So, you know, what are your suggestions about that, or you know, that balance that we talked about earlier?
My suggestion is that everyone has to make their own individual decision based on an understanding of what can happen and their willingness to take a risk. And, you know, I can't give a blanket suggestion. I know that at many of these demonstrations, the white members demonstrating are often asked to proceed to the front so that they can help protect the black members demonstrating, because they're quite often more likely to be subject to physical force by the officers. Those are choices that people will have to make, and I can't recommend one or the other. Be aware that the pepper ball injuries I've seen cause huge welts, that sometimes they're in sensitive areas. I have photographs of many of them. Someone was, I heard, hit in the eyes. I did see someone who was hit near the eye and had an eye infection. I know that of 2 broken noses. One was with a tear gas canister. I know that someone's shoulder was injured. I know that people have been traumatized emotionally by the circumstances they experienced. So really, it's an individual decision. And if you're going to go, I would say don't have any bare skin, because those pepper balls hit hard, and on bare skin, it looks like they're abrading the skin. People do bring makeshift shields, but don't have anything that looks like a weapon, because these officers are going to use every opportunity to treat it as a weapon and come at you harder. I don't know what else I wish I had better news for you or better suggestions, but it's just so individual. And we've seen really reprehensible conduct on the part of many of the police officers. We've seen them with people who have press passes or media on them and large cameras, specifically targeting them and shooting at them when they're out of the fray completely. They're off to the side just trying, and there is a special protection for the press. We have, you know, the freedom of the press in this country, but what officers have deliberately targeted press to try and prevent them from observing and recording and sharing what they've observed.
So I think the perfect comment to close with just came in from our interim director of community and belonging, Lisa Durant-Jones. We happen to have at the same time as this presentation some students that are marching and protesting today here on our campus. So, you know, what Lisa said was, as she listens to the students pass by the window today protesting, I am so glad we provided space to these student activists at NAS. And your, Jill Paperno, your presentation today is sobering, but it's important to those of us who speak with students to have this information. So thank you so much. We're certainly going to pass this information along so that it gets to be widespread among our campus. And I hope we can have some follow-up in the future with more positive news, right? And thank you every day, by the way, for the work that you're doing.
Oh, thank you. And really reach out to me anytime, either for general questions or if you're looking for guidance as to, I can't in my job that I have now direct to particular law firms, but just if you're looking for guidances or someone needs to know, like, what should I do next? I'm always happy to answer those questions.
All right. Thank you so much. And thank you everybody else for caring and for tuning in. And we'll see you soon.